practices to order. We have invited guests this evening, Mike Suley and John Silvestri, Esquire. And I'm sorry, I can't remember your name.
Barbara Stern.
Barbara, okay, Barbara. Okay. And Jared, would you please take roll?
From the beginning of the session, because of the reconvened session, we have Mr. DeMarco present, Ms. Filiaggi present, Mr. Petkowski present, Mr. Palmieri present, Chairman Katina present, Mr. Macy, Mr. Dewar, Ms. Nacarati Chapkus, and in terms of new attendance, we have Ms. Pritzio and Ms. Bennett, and I believe that's it. I'm
Okay.
sorry, no. Nope, that's everybody. We're good.
Okay. We have the approval of minutes 12479-22.
That was actually done in the original session as well. You're good to go there.
Okay, and then the agenda item. So we'll begin with Mike Suley, we're gonna sort of resume where we sort of left off last week or 2 weeks ago.
Yes, we will continue. As you know, I told you I was manager of the Office of Property Assessment at one time. I was vice chairman of the Board of Property Assessment Appeals and Review when the commissioners were here back in the 90s. But in 1990, I was also president of the Realtors Association. And I received this letter from them today, and I'd like to just read it into the record. I think the members here have a copy of it. So it's hot off the presses. It's on the Realtors Association of Metropolitan Pittsburgh letterhead. And it begins with honorable members of Allegheny County Council. We, the Realtors Association of Metropolitan Pittsburgh, request Allegheny County Council acts to open a second chance appeals window for 2022 of at least 30 days prior to the end of the calendar year. County Council has used their authority to open second chance appeals windows in the past to benefit taxpayers. The Realtors Association of Metropolitan Pittsburgh represents over 3,000 individual realtor members and is the largest advocate for real estate consumers in the region. There are hundreds of people that bought homes who have had their assessments appealed that could have filed an appeal right now, could file an appeal right now and get a lower, equitable, and just assessment. Without a second chance appeals window, consumers are left without this recourse path for taxes paid in 2022. For the benefit and equity of consumers, we ask that the County Council open a second chance appeals window. As always, our association and its membership is open to any dialogue on this matter. Additionally, we can provide any data, consumer testimonials, and research on this vital issue that County Council requires. Signed, Jim Jarrett. He's the president this year for the Realtors Association of Metropolitan Pittsburgh. All right.
Thank you.
Got that out of the way, and that was part of our agenda, Barbara and John and I. And I mentioned one last time that I walked up Forbes Avenue and pictured this building with that yellow tape, you know, when it's a crime scene. And today I'm thinking there should be yellow tape around the city county building and the county office building. All three buildings should be considered crime scenes. That's just my personal opinion. The actions began in this building 200 feet away from us in the county manager's office. Mr. Pilarski, back in 2012, when we had the countywide reassessment in 2012, the company that we hired, Tyler Technologies, reassessed each and every property in Allegheny County, 580,000 parcels. They did it over a 2.5 year period. And I worked with the chief assessor at the time, Wes Graham. I mentioned Wes Graham's name at the last meeting. At that time, we came up with values on each and every property at 100% of market value. Allegheny County, under an ordinance, must assess all properties at 100% of market value. At the time, Mr. Pilarski was the architect of a plan to reduce that 100% of market value to 92%. Let me explain it in layman's terms. If the assessors said that the house was worth $100,000 for assessment purposes, the county ended up certifying the rule at 92%, not 100%. Is that a good thing? Well, maybe it held down appeals somewhat because your assessment isn't as high as you had thought it would be. But now, here we are in 2022, 10 years later, and that was the first step in this process, that 92% of market value that leads us to this point. Maddie Gioffre, whom I've met, I've been to her home. My wife and I have visited their home in Wilkinsburg. They bought a home for $200,000. They now pay $9,000 a year for a home in Wilkinsburg. They are our lead plaintiffs. Last December, almost a year ago, they received a notice from the Board of Property Assessment Appeals and Review that their home was assessed at the sales price times the common level ratio, which was 87.5%. So you take 87.5% of their sales price, and that's how you calculate this. I'm not going to get into a lot of math, I promise. I told you the last time. But that's what they're paying taxes on, 87.5%. So in 10 years, according to the administration, the Office of Property Assessment, Mr. Pilarski, property values haven't really gone up that much in 10 years. We went from 92% to 87.5%, very narrow range. I think most of the people in this room know the property values have gone up a very high percentage. You can just look at any data that's out there, property values have gone up. If property values go up, the common level ratio should drop. That's how it works. So we went before a judge, and Mr. Silvestri will go over an opinion we received this week. I know Mr. Silvestri and I were invited to this, but tonight you're going to hear the words of Judge Hertzberg about what happened. And then afterwards, we'll answer any of your questions. So at this point, I'll just give it to Mr. Silvestri.
Thank you very much. I was out of town and participated by telephone the last time. And what I didn't do is introduce myself. I'll be brief because we're in a time crunch, but I'm currently on county pension. I worked for the county, and most of the years that I worked for the county was as either an assistant solicitor or the chief solicitor for the Board of Property Assessment. That's how Mike and I met one another. When he was on the board, I was the solicitor. The other thing is I've given up my idea that I enjoy politics. At one time, I was involved in politics, and I'm a former school board director of Northgate School District. So I know how that works from time. With that said, I want to make a correction because I don't know who it was, but towards the end of our last session, a female member asked if we could go backwards before 2022 to open up the appeal period. And my knee-jerk reaction when I heard that was no. And I don't know whether I said no or not, but I want to correct that because as I've been doing an analysis of the situation, because I went for the Board of Assessment last Thursday, a week ago, what I realized is that under the assessment law of a second-class county, and I'm going to present this to Judge Hertzberg in a separate case, what the Board of Assessment has been doing is using in 2022 the 2020 ratio for assessing. I think they should be using the 2021 ratio for 2022, the 2021 ratio for 2021 and the new 2020 ratio for 2020. So if you decide that the damage that has been done to property owners has been that severe, we do have assessing ratios to go back to the year 2020 for those property owners who have had their taxes increased. Now, with that said, before I go to the judge's opinion, the two people that I represented before the Board of Assessment on Thursday, and the representation was to request that they have late appeals for 2022. And Mr. Montgomery properly advised them of the law that if there is a breakdown or the equivalent of fraud in the process, then the board has authority to grant a late appeal. And of course, I won't argue here. You'll see it in the judge's opinion. One of the individuals of the two, the name is Sean McGill. He lives in Wilkinsburg on a street that has 1, 2, 3, 4, 5, 6, 7 houses. He bought in 2019. He was appealed in 2020. His assessment went from $125,100 to $325,000. This is after this year's appeal period passed that he got a hold of me because he read a newspaper article about the lawsuit. And he writes to me, I sold my home in Stanton Heights and my office building apartments in Glenshaw to buy this home in September of 2019. It was my dream home and allowed me a great home office. I own a social service organization where we meet with people in their homes and communities, people on the autism spectrum. Had I known there was such a risk for an increase, I would have never bought my home. I have a 17-year-old high school senior. He has attended Central Catholic, is now looking at a $30,000 a year bill for Point Park. I still have $500 a month on my student loan. The house needs a new roof. Garage is in terrible repair. My biggest concern, however, is my son and how to pay for his college. This has killed my soul, and all because I'm giving so much in taxes where there are properties worth double, nearly that are paying a fraction of that. So what I did is I looked at his street, and there's not one property assessment on his street, the other 6 properties on his street, that's over $178,000. His taxes went up 2.5 times simply because of the corrupt ratio. The other person I represented, his name is Ryan Shermack. This is brief. I bought my house in December 19. Mortgage was $1,155 a month, but now my mortgage is $1,875. That's, I mean, it's people buy their dream home and then they can't fix it up. There was a person at that board hearing who I did not represent. She was asking for an appeal. She bought her property. Coincidentally, Shermack is in Avalon, Northgate School District. There's another person who I did not represent. She spoke after I did. She was asking for her appeal to be resumed. She lives with her family in Bethel Park. The reason why she wanted a new hearing is because she missed the notice of the decision to know to appeal. They bought this home as their dream home. She was pregnant. She had twins. She said with the twins, she wasn't paying attention to the mail. She says that they bought it with the idea of fixing it up, and now they don't fix it up because if they fix it up, they don't have money for food. That's what's happening with what Pilarski and company have done. And the last person is, I represent a lot of people who I call bottom feeders. What they do is they buy the foreclosures, they buy the dilapidated ones, they are scorned upon in the community, but if you talk to realtors, they say these are the people who are improving the community because they fix them up and they either flip them or they rent them. So I'm doing a study of sales in McKees Court, going down the street. My client bought a place on Versailles Avenue in McKeesport. And I see this with regularity in McKeesport. Here's a family that bought their home in 1970 on Versailles. It's assessed at $52,000. There is nothing on that street that sells for more than $30,000. This is someone who wasn't appealed, but is in an underserved community. And if this person would have the opportunity to file an appeal, the taxes for this person would be at a $30,000 market value times a 65% ratio, which brings them below $20,000. They're paying double the taxes that they should be. So this isn't just about the people who've been appealed. This is about the people in our community that we're supposed to help in the underserved community. I'm sorry I get emotional over this. I get irritated with what's happened. Simply because I know better. I used to be in the government that did this. Okay. Is it possible to have both the bottom of page 1 and the bottom of page 2 on the screen at the same time? Okay, great. This came out on Monday, November 14th at the end of the day. That's a little bit fuzzy. What Judge Hertzberg begins with is quoting the law, and because it's fuzzy, he quotes the law that says, as every tax is a burden, it is important that the public has confidence that property taxes are administered in a just and impartial manner, with each taxpayer contributing his or her fair share to the cost of government. This lends legitimacy to the property tax system in the eyes of the public, which in turn tends to suppress both the desire to evade taxes and the tendency to embark on protracted litigation, which itself consumes large quantities of societal resources. So the judge quotes that. That's a Supreme Court case. And the judge goes on to say at the bottom of the page, Allegheny County failed to administer the property tax assessment appeal system in a just and impartial manner. That's a judicial finding. After this was detected and exposed, and that's what the lawsuit did, it exposed, Allegheny County agreed to rectify the situation. And then he goes on to talk about the school district. A beneficiary of taxpayers contributing more than their fair share refuses to allow the county to accept responsibility and correct its improper assessment system. What the judge is saying there is the county appealed, the school district appealed what the county's work did that showed that the ratio was not 81.1%, but 63.5%. That's 100% county work. If you need to see the backup for that, I have the transcript where the county solicitor went into court and said, we are presenting our sales. We are rejecting anything that we want to that the plaintiffs gave us. This is 100% our work. So if we go to pages 3 and 4, the bottom of 3 and the top of 4, and this will be the last part of the judicial opinion. And I'm not going to read everything in here. And that top line in the box at the bottom of page 3, the sentence begins, Allegheny County's Office of Property Assessment Manager, his name's Jim Davis, during his deposition testified that its computer program automatically invalidated special warranty deeds outside of the 80 to 120% ratio and automatically validated transfers in the 90 to 110% ratio, and then sent both groups, instead of saying STEB, I'll say state government, without any review by a human. Jim Davis is now your deputy director in administrative services. I know Jim Davis from my practice in this area, and I don't want to defame anybody, but I would say that he is one of the few individuals who desires to be truthful, if he'd allow to be truthful, and he was as truthful as he was allowed to be in his deposition.
Question.
Yes,
So just to clarify for everybody, when he testified the computer program automatically invalidated the special warranty deeds outside of 0.80 to 1.20 ratio, what impact did that have?
it automatically sent to state government higher ratio sales that inflated.
So it artificially inflated the numbers, if I'm reading that correctly.
That is correct.
Okay.
You pay more taxes based on that artificial number.
If I could add, there were special warranty deeds, there were 4,699 of those that were invalidated. That's a huge amount, particularly in contrast to the fact that there were only 5,300 validated sales to compute the ratio. So by eliminating that enormous volume, by disqualifying them,
Then they eliminated 75%. You're basically 75%,
there were 4,690.
more than 75. Okay.
Yeah, so when we audited that group, 76% of them have no reason for invalidation. So of that group of special warranty, they invalidated thousands of them. And, you know, when you stack them all up, and there's only 5,000 or so in the group, and you've automatically eliminated the low ones, the middle one moves.
You're artificially
You're
inflated.
shifting the
Yeah.
median, the middle value. And in the reverse, they added to them any one that was coded UR, unverified valid ratio within
Tolerance.
tolerance, thank you. They added them in without verification, and those were added if they had a ratio between 90 and 115. So by adding invalid sales to the top of the pile with high ratios and removing the valid sales from the bottom of
It
the pile,
shifted.
it went from 83.5 to 81.1.
Turbocharged.
And those are only the ones that we were able to review. Individually, I reviewed and worked with the county to bring to their attention the mistakes. I alone. And if I had had more time, that number would have moved even more dramatically because it was a singular person calling to the attention for them to review their mistakes.
What was the county's response when you showed them that information?
So I worked with a woman who was the assessor, and for the most part, she tried very hard to do a good job. But it was clear to me during that work that they weren't trained, that she struggled in training her staff. She would take work home individually at night herself to review the work that her reviewers were doing. But frankly, they really didn't understand the rules that were in place, and they didn't have the skills. They didn't have both the skill nor the equipment to do that. For example, they didn't have access to the West Penn multi-list. So they weren't able to verify certain things. They didn't read the deeds. One of the invalidation codes is for an estate sale. If it's an estate sale, it's not a valid sale for STEP's purpose. They don't read the deeds, so they didn't know. So in addition to what the software did to automatically make these enormous adjustments improperly, those that were kicked to them for review were also miscoded for various reasons. So she did try, but she didn't have the resources, nor did she have the training, she herself nor her staff. So we would debate things. Sometimes we came to agreement, and if we didn't, she kept the coding as she chose it. And that was her submission to the court and to STEP. So there was never a change to any code that they didn't agree with us on, or that they themselves didn't just say, we're ignoring you, we're taking our data. So it was 100% their work. There wasn't a single submission that was not the county's work.
So,
Mr. Chairman,
go ahead, Councilman DeMarco.
before we move forward, I'd like to ask her to recap those numbers that she provided. You know, so when the county provided the data that they used, how many property sales did they incorporate?
How many property sales did they incorporate? I think he said.
How many properties were
Yes.
used in the computation of the ratio?
Yeah.
5,355.
Did you
Okay,
get
and
that?
you
Sam?
said how many? Yes, sir. And
Okay.
she said, how many did they exclude that she was talking about that fell outside those parameters that would have lowered this rate if they had included them?
Right. So I have a summary report if you'd like me, rather than to go through a lot of organizations of that data, I can give this to you. Would you?
Yeah, we'd love to have that. Thank you very
Yeah,
much.
you could, yeah.
Sure.
Thank you, Mr. Chairman.
Yeah. Oh, okay. Yeah, thank you.
That makes it simple.
Thank you, Mr.
We'll
Suley. So-
always,
We'll
Well,
get it out to everybody.
all right, thank you, sir.
Yeah, and just to say that the 5,355, it was actually 5,057, there were two duplicates, was out of a total of over 34,000 transfers that year that could have been chosen.
I'm sorry, can you repeat that?
So they chose to be valid only 5,355 out of a possible 34,563. And that's very low. And at the end of our work in reviewing, we had over 10,000 that were used to compute the new ratio that they decided they had mistakenly coded. So now there were 10,116 used to compute the new ratio.
So,
Yeah.
You basically doubled what they accepted. Okay.
And lowered the ratio.
so if you showed them this, and I'm gonna leap here a little bit. If you showed them the error of their ways, and then they went back and recalculated and basically agreed with everything that you were showing them, I guess I'd go as far as to say, in my opinion, might that be an admission of guilt?
I mean, how can we say anything other than yes,
How's that?
which they agreed they did it.
They agreed it was done wrong, I guess is the best way to put it.
Indefensible.
That's right.
Okay.
And some of it is just really factual. For example, it either is on the market or not. If it's not on the open market, if it was never listed on the multi-list and you sold it to your brother or your child or your neighbor, it's not a valid sale. And you have an example, yes. And so it either is on the market, thank you, or it isn't. And so those are factual things. There's nothing speculative about that. The other thing is frequently family sales. It would be Pat Katina Senior to Pat Katina Junior. I mean, it is obvious that is not an arm's length sale. That should not be used. And there were also government sales and estate sales and many, many, many reasons for exclusion. And those were the things that we went through. So it was very difficult for them to say that this is not.
Well, they agreed with everything you present 100% of the time, correct?
The percentage of I have another more extensive report that talked about the percentage of them that we submitted to them that they agreed to. It is a very high percent.
Could you get us that as well, please,
I
when you
would
get an
love to.
opportunity?
Sure.
We don't need it tonight. We'll
And
do-
Councilman, everyone, very important to know that when a realtor puts a home on the market, in the West Bend multi-list, for that year, we found 16,000 closings. If you put your home up with a realtor, the realtor prepares an agreement of sale, the standard agreement of sale that everyone uses. It has in there, it's a special warranty deed. And what we just are showing you was, it's a slam dunk. It's a special warranty deed. You have a buyer and seller who really don't know each other. There's exposure on the marketplace, and these were all thrown out and not put into the calculation. It's criminal. This is my opinion.
And you would speculate that was done why?
I can't get in their heads. What is in, he will.
I
Don
have
will.
a document that shows why they did.
Okay,
Yeah, I can't answer that.
okay.
They really screwed up, and people are paying for this still today.
Is the document is that in here or is that something separate? that
Oh, no,
you need? It's in this, okay, it's in this presentation.
You asked for that, so I
Okay.
found one.
Okay, perfect. So I'll let you proceed.
Okay, then at the bottom of the page, the last sentence that begins at the bottom of page 3. Allegheny County's acting chief assessment officer, and that's Dee Hennon, who I mentioned at our last session, during her deposition admitted the automated nightly computer programming operated to increase the common level ratio calculated by STEB, the state government. So you were looking for an
Where is
admission?
that?
That is an admission.
Oh, there it is, sorry.
And then the very last sentence in that box on page 4 is what I call the judicial bombshell. Judge writes, and I quote, "From this evidence, there could be no doubt that Allegheny County's Office of Property Assessment had been, quote, cooking the books, end quote, on CLR data submitted to state government." Okay, if we go to page 11, the rest of the pages are the rest of the judicial opinion. I just wanted to highlight the judge's findings that there was falsification of reporting to state government. Okay, I was given about 300 pages of monthly reports. These were authored in part by Mr. Pilarski's chief assessment officer that he chose, the computer person. I do not criticize her. She was put in a situation that she didn't ask to be put in. But what she's reporting, and this is the 85% that I described, or Mike described at our last session, of what they were doing that drove the inflation. And if you move to the very bottom of the page, you'll see that I have a box around the topic of sales. And what Dee Hennon writes, and you see Dee Hennon's name in the bottom left, she compiled this on January 13th, 2021. So we're talking about the 2020 sales data. So what they do is every time they send to STEB, they add to what they've sent to STEB. By STEB, I mean state government. And they calculate the running common level ratio, so they know where it is. It's no surprise. They know where it is. And at that point, 32,737 sales were entered into their system. And their partial year common level ratio through November was 84.26% using one method and 83.26% using another method. And the last sentence is where we have the telltale of what's going on. She says, both versions have now entered reval territory under 85%. So what Dee Hennon thought, and I asked about this in depositions, is where did you get 85% from? And she doesn't know. I ask others, where's the 85% from? They don't know. Apparently, they were given misinformation that if you go below an 85% assessing ratio, you have to go through a revaluation process. That is 100% wrong. But of course, we have a chief executive who said that he will never, ever, during his administration, allow a revaluation. And if someone is thinking that if you go below 85%, you're in reval territory, they're going to follow what the chief executive says, which is keep it above 85%. There are other pages, and you can see every month that they're looking at what the common level ratio is. The next sheet on page 12 is what I call the cheating sheet. When I was in high school, we used to have cheat sheets for our tests. We'd try to cram everything on an index card so that we would know what the answers were. Of course, we couldn't use the cheat sheets when we were taking our exams. So in memory of my high school, I call this the cheating sheet. And this is a piece of paper that individual coding people were given to code deeds. Now, you've already heard what Mike has said and what Barbara has said, that the gold standard on whether a sale is valid is if it is an open market, arm's length transaction. It's two parts, open market and arm's length. Open market means it's listed on multi-list. Arm's length says that even if it's listed on multi-list, a sale by a financial institution, a bank sale, a post foreclosure sale is disqualified from being valid. That's the state government regulations. So you can't read it unless you have a magnifying glass, but the very top line of their cheat sheet is for valid sale. And what I did is I typed that at the very top, valid sale code 0. And it's described as a code description, valid sale, a person-to-person sale, assessed value to sale price ratio between 85% and 115%. So when they were presented on their computer screen with the assessed value, the market value, which allows them to compute an assessing ratio. If the assessing ratio was above 85% for that property, which of course matches the last exhibit, you don't want to be 85%, or you might have to have a reassessment or revaluation, then it's automatically validated. And it doesn't make any difference whether it was on the open market. It doesn't make any difference if it's an arm's length sale. All that makes a difference is if it's high. And when I questioned Jim Davis, who is a very competent assessor, he did admit that a ratio of an assessed value to a sales price is not a criteria for a valid sale. So what I have next are the first page and an attachment to a deed. This is one of the deeds that Allegheny County in their papers said this was reported as a valid deed. And what I did is I asked questions to the county in the lawsuit. I said, do you agree that this is a family transfer? Answer, yes. If so, do you agree that this should not have been a valid sale? Answer, yes. What would have you coded it if you are not coding it valid now? And they said that they would code it as a family transfer. So this is a very interesting transaction because the assessed value is $50,000. The the assessed value is $51,400. The sale price is $50,000. And what's interesting is that the ratio of 51,400 divided by 50,000 is 1.028 ratio, which is exactly what this manual coding sheet says you're to valid a sale with. The employee who coded this sale at that time, right now, this employee is the head of the Department of Administrative Services. Her name is Jessica Gioffre. At that time, she was the operations manager in 2020 who coded herself and supervised the coders. I brought this deed to her deposition and I showed her this deed. And if we turn to page 13, you see that the deed is from the Letters family to the Letters family. Right off of the bat, you know that it's a transfer between family members. Right off of the bat, you know it's a state regulation that it has to be disqualified. But it has a 100% ratio, and what the county guideline is, not the state guideline, but what the county guideline is, put it in as a valid sale, even though it's not valid. Now, you heard, and I verified this, that they don't look at deeds, but that doesn't make any difference with Jessica Garofolo, because when you look at the county screen, you're told the name of the buyer and the name of the seller. So she had to be looking at the last name of the buyer and the last name of the seller to know that this was a family transfer. And had she gone out on the internet to see if this was open market, this was not open market. Is this an Aspinwall? The next page will tell us it's Fox Chapel School District, Main Street, Sharpsburg. Okay, this isn't Sharpsburg. This isn't a home. This is a family business. And this is an exemption. Apparently, you don't have to pay transfer stamps if it's from a parent to a child. Part of this transaction was from parents to their child, Nicholas. The parents of Nicholas also had brothers, so Nicholas's uncle and aunt were also in the transfer. So that part you pay taxes on. From the parent to child, you didn't, but this family was just passing on their family business. I doubt that $50,000 is really paid, but that's besides the point. You have someone who's been promoted by Pilarski to run the operation, and in her deposition, and I'll be glad to pull it out, she was belligerent. She said, I would code it the same. I stand by my work, and her work is not only wrong, but the county said it was wrong in their court papers. Okay, moving on.
Did you provide that? I'm sorry, did you provide that to us already, or is that,
I haven't pulled that transcript out. I can do that if you want.
can you get us that, please?
I will do that.
Thank you.
Next, I have some excerpts from D. Hennon. I see that we're about quarter two. Trying to think what we should do.
Why don't we actually open it up? My plan is to have another meeting next
Okay.
week before our 5 PM meeting. So I'm gonna recess tonight's meeting and reconvene at 4 PM next Tuesday.
Okay.
So we'll have an opportunity with this still fresh in everyone's minds to basically still continue this and see if there's any questions right now for what we've already gone over.
Just let me say one sentence.
What's that?
The transcript that I'm going to show you, the next area is, I asked, whose idea was this for the computer program? And I'll just leave it at that so that you have a suspense of what we'll get.
News at 11.
If you don't mind, I'd like to leave you out of suspense because I found some numbers that regarding your question previous. As I mentioned, there were over 34,000 potential sales in that year 2020 that they could have that they reviewed or should have submitted. As a result of the work that we initiated, 12,671 of the sales were recoded, either valid to invalid or invalid to valid. That's a dramatic percentage. It's mind blowing. It's about a third of the sales were recoded as a result of the work that we initiated from our side.
And if this lawsuit hadn't been brought, none of this would have been caught nor corrected.
It's very complicated.
What John's describing, these are not isolated instances. These are hundreds of these.
Thousands.
He's describing one specific circumstance of that, but in all of these different codings that are, codings for step to be coding to categories, there's hundreds of violations in each of these categories.
And I may add, under a court agreement back in late April, the three of us were the oversight to the county assessment office. And we had to, when I say oversight, they had to share information.
Let me explain that. The county objected that we look over their shoulders. The judge looked at me and I said to the judge, they have no competent chief assessment officer. We have to be the competent chief assessment officer to oversee this. And the judge says, yes, that's what we have to do.
Okay.
Okay, questions?
Councilman DeMarco, we'll start with you. Any questions so far?
No, I think this testimony that we heard today, or what we're hearing, is very disturbing from my perspective here. And I look forward to learning more and hearing what any justification, for the exclusion of these properties that should have been considered, were. Look forward to the next meeting. Thank you, Mr. Chairman.
Thank you. Councilman Palmieri?
No questions, Mr. Chairman. Thank you.
Thank you. Who else do we have on? I'm sorry.
Palmasina.
Councilman Palmasina, any questions?
No, Pat, thank you. But we will get an update on what was discussed tonight by email.
Yes, we'll send out any information that we owe you. We'll get it out. I think Ken already sent one piece out to your emails actually during the meeting, so you should have that already.
Nope, that's
And-
fine. Thank you very much, and thank you, gentlemen, for your report.
Thank you. Councilman Macy?
Thank you, Mr. Chairman. And I certainly want to thank our guests for that, the factual information. I think about Dragnet, and just the facts, man, just the facts. One comment. I purchased my house some time ago for $100,000, and I do know when there was a reassessment, I had what they would refer to as a drive-by, and my house went from $100,000 to $174,000, and it had a deck off the back of my house, which wasn't there anymore. It was torn down because it was become structurally insufficient. So all of this information is very important to me, and of course my district is one of those districts that is a place in dire straits, and we could use all the help we can get down here. Thank you so much.
Councilman Dewar?
No questions, President Katina. Looking forward to the next meeting, though. Thank you.
Thank you. Councilman Bukowski, I'm sorry, I missed you earlier.
That's okay, Pat. No questions. It's just a bit overwhelming.
Yeah, I totally hear you, Councilman. Liv, Councilman Ben, any questions?
No, thank you all.
Councilwoman
No,
Christie?
thanks for that clarification. This has been very, very enlightening for me. Thank you.
Okay, so actually, I mean,
Hey,
we have
Chairman?
10 more. Go ahead, Councilman.
This is Councilman DeMarco. What I would like to suggest is that if Ken can take and create a folder in which all of these documents could be put in for our access. I mean, Mike Suley, as well as Mr. Silvestri and others, have provided us documents over the period as his committee has been ramping up and getting ready to proceed with these meetings. I'd really like to have one location where we would have all the documents accessible so that we don't miss anything here. That would be helpful. Thank you, Mr. Chairman.
Yes, Ken will take care of that.
Thank you.
I'll let you continue because we have 10 more minutes, so we might as well go on. Use our time.
Okay, but before I do that, I'd like to introduce Barbara Stern. Her degrees are mathematics and computer science. Her work was in the real estate area. She was in a family that was a real estate developer. As part of the real estate development process, she became licensed as a real estate salesperson, knows the business. And when I was a solicitor at the Board of Assessment, she was representing her family properties and doing tax appeals. So she started to learn about the tax appeal process.
Before you go on, could you provide us your resume or anything like that so we can add that to the record, obviously? Thank you.
So the way this lawsuit starts is she was looking at a property, and when she looks at property for tax appeals, and she's a tax appeal consultant, what she does is she gets the property record card for the property from OPA. You can just ask for any property by email, they'll give it to you. And one of the parts of the property record card is the way the property is coded. and it can be coded as a valid sale. It can be coded as a financial transaction, bank sale. It can be coded as a family transfer. It can be coded as an estate sale. It can be coded as a government transfer. There are many disqualification codes. Everything is a disqualification code unless it's valid. And when she was looking at the coding of properties and what the school districts were presenting as valid sales, she didn't get a match. 3 out of 4 times, she would see that the property that was a valid arm's length sale that the school district was presenting as evidence was coded as an invalid sale by the county. And when she looked at the sales ratios, they were all in the 50s and 60s percentages. So she came to me and said, this is what I'm finding. This seems to be wrong. And I said back to her, I tried to sue the county 3 years ago. I didn't tell you about that lawsuit. I gave up on it. My client was an economist at the University of Pittsburgh. And I didn't have people working with me to support all of the work that needed to be done. So I discontinued the lawsuit. So what we ended up with was Barbara presenting the hard evidence to me that the county was cheating, me doing some extra reading, her doing some reading, connecting with a professor at CMU who does statistics work. He offered this to a student for PhD studies.
Could you please mute your phones? Whoever's on the phone, please mute your phones. Thank you. Go ahead.
And of course, Mike Suley and I have worked together on this type of issue in the past. So we have a team that includes this computer mathematic savvy woman who discovered the discrepancies in the coding. We have the professional of years who worked on both the inside and the outside that knows the real estate business. There's an additional person who called me up. He does spreadsheets for hedge funds at one of the big accounting firms. He was able to put together the spreadsheets that we get from the state government, the spreadsheets that we get to the county in order to do this discovery. And then there's, of course, there's little old me who doesn't know anything except reading the rules of evidence, doing an investigation, and writing pleadings as I was taught by the judge who I clerked for when I began my career as an attorney. So I just chugged along, and there's no way that this could have been done without the team that I've described. So I mentioned that to you. I only intended to introduce Barbara, but for you to know who the whole team is tells you that we have multi-professional disciplines, and we have done all of this work without either compensation, it's pro bono work, or any desire to be paid for it. We are simply doing this because we see something that's wrong. We see how people are stressed out, and we want to right the wrong. And I'll end this by saying, Mike Suley, when we were both doing assessment cases 15 years ago, referred a client to me. It was when the Board of Assessment was illegally holding hearings. I filed a lawsuit on behalf of his property owner. I lost in front of Judge Weddick. I lost on the appeal to Commonwealth Court. The Supreme Court of Pennsylvania accepted it. They reversed all the way down. They made what the Board of Assessment was doing, declared it illegal, and it's changed the way the assessment board holds hearings today. So and that was all done pro bono. It's what I call, after serving county government in this area, wanting to do a good professional job, sometimes being prevented by the county commissioners because they have their own agenda, is I wanted to give back, and that's part of why I'm involved in this thing. So do we have time to keep on going 5 minutes?
Can I just add something? I've worked just as property owners for a long time, and people that would come to me wanting help because they were sued by school district for increased I didn't want to do it because you're going to lose. And I didn't want to be paid for anything for which I would not provide a benefit. But when this happens to you, and I'm going to urge each of you to pretend it happened to you, pretend that you bought your dream home, right? Your realtor didn't tell you. They said, oh, you might have an assessment change, but you don't really know because your realtor doesn't really know. And honestly, who does know, right? So it's happened to you. So you get a lot of letters. You got the one that said you're being sued by the school district and you're like, ooh, what do I do? What's going to happen? You get a million solicitation letters from a lot of attorneys that want to hire you or want you to hire them. They charge between $1,000 and $1,300 to do this work. So these people that have been challenged this year for an increase by the school districts, many have hired people. So in addition to the additional cost of this challenge, in which case you're going to lose until now, you would lose in your assessment. You've heard examples of what happens to your assessment, but you also paid $1,000 or $1,300. And those attorneys don't tell you about the common level ratio. They act as though that was their work. So the letter that you get says, you're being sued, your taxes are going to be increased, you should hire us. You paid $300,000, they're going to be asking for your increase. They never tell you that a ratio is automatically applied. So in addition to insult on top of injury, you pay this. And you think that you've paid for a service. So now the question is, now that the school districts are permitted to withdraw these cases because the ratio has changed, now they're only withdrawing the cases when they could lose money. They're not withdrawing the cases where they can get money. So why shouldn't a property owner who now has this issue of a new ratio to consider, why shouldn't they have the same opportunity to file an appeal, to change their decision, just as the school districts are permitted to withdraw a decision? That kind of sounds fair to me. So the last thing I'd just like to share is the fact that John talked to you about an example of the people on a street where we have declining value. These people only, if they are savvy enough to go on the county website, and I urge you all to do it, try to figure out what your home is worth. You go on the county website and you're going to get your assessment. And if you think that math is confusing with what we've shared to you, try to figure out what your home is worth. I'll give you the cliff notes. What you need to do is take the common level ratio factor, which is the inverse of the common level ratio, which is 1 divided by the common level ratio, and multiply that times your assessment. Now try that for fun to figure out your market value. There is nowhere where you can find it. It doesn't come on your tax bill. It's not on the county's website. So when you say to yourself, here's my tax bill, my assessment's only $53,000, you know, should I file an appeal? You don't even know what your home is worth. None of you do.
Right.
So,
So
in a perfect world, the county would go back and identify anyone that was basically harmed by this per se and fix them, right?
it's easy for them to do it. They know, we know there's 12,000 appeals this year
I
approximately.
mean, because really, you talk about expense. So if the appeals window is reopened, there's if people are, that's just an additional, the way I'm looking at it, that's just an additional hurdle that we're putting on the residents of Allegheny County when it was a mistake possibly made by the county.
Yes.
That just doesn't seem equitable or fair to me. It seems like it just ought to
We're
be done
gonna
on
come
its
up
own.
with some suggestions next week, the three of us. 'Cause we're the ones that been together 2 years on this project. We're gonna make some recommendations,
Okay.
just based on our experience. I want to just share one story with you. Mr. DeVold lives on Herman Avenue in Duquesne. I met him on Monday. He bought a house in Duquesne. This is Councilman Macy's district, I believe. And he paid $120,000 for the house. The school district appealed it at the 81-1, which Mr. Pilarski created. And on Monday, he said, should I get an attorney? I have a hearing on Thursday morning, tomorrow morning, Duquesne property. He paid $120,000 for the house. Should I get a lawyer? what does a lawyer cost? $1,000? I said, no. I did the math. The school district is still going through with this appeal. His school taxes are gonna go up $150 with the ratio that was readjusted. His taxes are only gonna go up $150. The school district hired a lawyer. They had to file the appeal. A lawyer, a school district lawyer is gonna show up tomorrow on the phone and someone is paying this person. This poor guy, without me, he would have hired a lawyer. And his taxes, his school taxes are only gonna go up $150 because of what we did. That's a crime. I just get so upset. And I see the people down the hall here in the county manager's office, they don't talk to these people. All they do is, keystroke the computer to inflate the tax bill. And until there's a reassessment for the next 10 years, if you do nothing, if council does nothing, they're gonna continue to pay inflated values.
Let me talk about the lawyers just real quick. I get calls all of the time. The school district has appealed me. My neighbor said to call you. May I hire you? This is the John Silvestri standard answer. Don't pay me to defend you. Don't pay any other lawyer to defend you. What will happen is the school district will give you a purchase price. The Board of Assessment is trained to use that as the market value, and they rubber stamp the 87%. Doesn't make any difference whether you have a lawyer or you don't. Find out how much they're charging. Set that amount aside in the savings if your budget's tight. If your budget is not tight, put on drinks the next time you go out to dinner. That's exactly what I tell them. I said, if after you get the decision, we think that there's an opening to get you reduced, I'm glad to represent you on getting it reduced in court, but don't pay any money to lawyers. And the last thing I'll say on the topic of lawyers, I've had people tell me that lawyers have solicited them to say, the school district is going after your purchase price. We will get it reduced below the purchase price. And that ties into what Barbara just said. After they get a 15% reduction from the ratio, they beat their chest and they say, look what a good job we did. As far as I'm concerned, they need to be reported to the disciplinary board and lose their license.
They know what we know.
In addition to the school district attorneys being bad actors, there are also a lot of bad actors. It's, there's a TV show that says, follow the money.
Yeah.
Yeah.
Okay. At this point in time, we're going to recess and we'll reconvene next Tuesday at 4 p.m. Thank you, everyone.
Thank you very much.
Thank you.